Thank you, Jeff, very much. And thank you to all of you who support this and your efforts behind it. Greetings from your Attorney General, Dana Nessel, who regrets that she could not make it this morning due to a conflict in her schedule. So you get me. And I was so excited I wore my lawsuit for you today. So. And who's the 12-year-old? What is your name? Sanique. Okay. That's one thing we all have in common. We were all 12 at one time in our lives. So it's good to see youth here too. Well, I do a lot of FOIA training for the state of Michigan, so that all State Department FOIA coordinators are required to go through once or twice a year FOIA training so that they serve the public to the fullest extent possible and do so efficiently and do so with vigor. I tell the FOIA coordinators they should be proud about their position as gatekeepers of the First Amendment. Then they look at me somewhat quizzically. What does that have to do with the First Amendment? Well, all of you here know what the 5 rights that compose the First Amendment are, right? If I asked any one of you, what are the 5 rights that compose the First Amendment, you would be able to tell me that. Well, quite frankly, I had to memorize it myself. A little poem. Speech, press, petition, assembly, and religion. And those first 4, speech, press, petition, assembly, those first 4 rights have everything to do with the Freedom of Information Act and vice versa. And what I call FOIA's first cousin, the Open Meetings Act, both statutes enacted in 1976, effective 1977 in the state of Michigan. And all 50 states and the District of Columbia and the federal government have such statutes. We have heard of the federal FOIA. The Open Meetings Act at the federal level is Government in the Sunshine Act. Isn't that poetic? Okay, so we see that all governmental bodies have these statutes. Yes? Oh, someone's toying with our freedom of information. So why don't you see if you can. Actually, it's a 1 frame. There you go. It's 1 frame giving you the sections. I went to sleep? Okay. Very good. Well, if it happens again, I'll just tap that. Very good. Yeah, and as technology increases, so does information, doesn't it? Sometimes when I get home and open my mailbox and listen to my voicemail, both on my landline, which I still have, and on my cell phone, and I get all that solicitation for buying this and buying that, and robocalls that our office is trying to put a little bit of a damper on. When I look at all that, I want to call my legislators and say, can you pass a Freedom from Information Act? Because sometimes it just seems like we're inundated with information. But that aside, this statute is important. I know that a paper was written during the Obama administration on the importance of these statutes. And in that paper, it said, government transparency ensures the public's trust, collaboration, and participation. It promotes accountability, thus trust in what our government officials are doing. It promotes openness, thus collaboration in the work of our government. And finally, it promotes diffusion of information, participation in our democratic process. And the context, the historical context to all this, goes back to the founding of this nation, goes back to one particular founder, James Madison, who was a prolific writer about the importance of information and the dissemination of information. He's even quoted in some Michigan Supreme Court FOIA cases because of what he had to say. And if you ever visit the Madison Memorial, which doesn't get as much publicity as the other memorials, you will see plaques on the outside and in the interior of that building engraved with many of these quotes. He said that knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. He says nothing could be more irrational than to give people power and to withhold from them information without which power is abused. And one last quote I'll share with you. The advancement and diffusion of knowledge is the only guardian of true liberty. And when he talks about diffusion of knowledge, think about it. Freedom of the press. The fact that the Fourth Estate, that arm of our society, how important it is to get information out. And despite all the different media that we use today, it's a constant source of information. So why do we have a FOIA? It's the means of acquiring information, quite simply. It promotes and safeguards the First Amendment, as I stated, and our state constitution, both First Amendment in federal and state constitution, freedoms of speech and press, etc. Okay? And we see the same then at the federal level with the federal FOIA and its counterpart of the Open Meetings Act. So, looking at the 14 sections, although they're not consecutive, there's numbers missing, and that's not unusual in a statute. It's a short statute. It isn't very complicated. It's that worn out expression, it's not rocket science. If that's the case, then why do we have all these Court of Appeals and Supreme Court decisions on FOIA cases that made their way up the pike of the judicial process with people disputing whether FOIA was applied properly or not? In Michigan, there are over 10,000 public bodies subject to the FOIA. 10,000 at the state, county, and local level. Every school board, every township board, every city council, every prosecutor's office, all the state departments, you start to think about it. That's a massive amount of public bodies subject to this act. But notice what branch are we talking about? The executive branch of government, which, as you know, currently excludes the governor and lieutenant governor's office, much to the chagrin of now Governor Whitmer and Attorney General Nesso, both pushing for the governor's office to be included as legislatively included as part of FOIA. The courts didn't accept themselves, but the legislature did accept the courts, so the Supreme Court and all courts are not subject to FOIA. Now, mind you, there are other ways. Those of you who are attorneys know there are other ways of accessing court information under the Michigan Rules of Court. You can go to a county clerk's office for a court and ask for records and pay whatever it is they might charge. So when we say that certain entities, governmental bodies, are not subject to FOIA, it doesn't mean they're off limits, because there's other ways of acquiring information. Okay? I don't know why that's going to sleep. Come back. But you've got subpoenas. You've heard of subpoenas. You've got discovery that you can do when you're suing a governmental body. So there's other ways of acquiring information. We're not talking about those this morning. We're talking about the Freedom of Information Act, that wide open gate where all of us as citizens can acquire information. I say citizens, quite frankly, FOIA does not have any residency requirements, doesn't have any age limitations. Any and all persons, individuals and corporate persons, can seek to acquire information from any governmental body in the state of Michigan. So if you're a resident of Ohio and you make a FOIA request to the Department of Treasury, the Michigan Department of Treasury, it's a FOIA request that must be processed, okay? I don't know why we're not getting this on, but I don't need it. I can tell you the section numbers. All right, so every statute has to tell the people why we have a statute. We have a right to be put on notice why the legislature, representing us, decided that we need to have this statute, and then tell us what our responsibilities are under the statute, what our rights are under every statute. So it says, it is the public policy of the state of Michigan that all persons, with an exception that I'll talk about very briefly, are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and public employees. The most reflective purpose of any statute. Why? So that the people shall be informed to fully participate in the democratic process. There's your First Amendment tie-in. We need information, Madison said, because it gives us power, and it's the power of self-governance. And we know the history behind all that time. Who are they trying to get away from? Somebody, some form of government, if you will, that controlled all information and gave little, if nothing, to the people that were being governed. So what is a FOIA request? It could be a red crayon on a paper napkin. That's how simple it is. There's nothing fancy about it. It's a written request. You used to be able to make verbal, but before you sued, you have to reduce it to writing and then get denied, and then you'd sue. So the legislature said, let's just say it's a written request that describes a record sufficiently to enable the public body to find the record. That's the only burden on we, the requester. we have to describe it sufficiently. Please give me any records you have. It's not going to cut it for most FOIA coordinators. And when I say FOIA coordinator, that's a term of art. That's an official position in the legislature, Section 6 of the FOIA that they gave to every public body, a FOIA coordinator. Only the FOIA coordinator can process the request. Only the FOIA coordinator can deny the request. So no other employee of any public body is legally permitted to handle it. Now, the FOIA coordinator can delegate somebody temporarily if they're going to be away on vacation or whatever in writing to handle it. But again, it's a very specific position. The FOIA coordinator is the go-to person when you're making the request. So you describe the record sufficiently. That's in Section 3. Section 3 of the Act then is telling us about who the parties are going to be in this relationship. FOIA is all about relationship. It's your relationship to the government. So it says any person may ask to inspect records, to copy the records. You want to bring your own copier in? You can do that legally. I don't know why you would do that, but you could do that. It happens on occasion with massive requests from corporate requesters. Or you can demand copies of those records. Those are your rights. Can you be asked why you want it? Can you be asked what you're going to do with it? Well, we get complaints from citizens that my local unit of government did those things, inquired of me why I want it. What am I going to do with it? No, that is not legal. The FOIA coordinator has on blinders. It just receives the request. It's specifically described. It coordinates the gathering of the information. It determines if something might be exempt from public disclosure. We'll talk about that briefly. And then gives that information. This is a FOIA process. It's records, tangible records in the possession of the public body. I don't even have to look at it. Here, that's it. This is it. There's FOIA. That's your optic, okay? That's it. It should be that simple. Yet we know there's a lot of angst and back and forth disputes about such things. But it does work. I think it works quite well. And it works much better than sometimes we think it does, because when you think of 10,000 public bodies that are processing requests, as we are sitting here, they're processing requests, and we look at the amount of case law we have on it, proportionately it's very small. Very important, mind you, but not as much as you think. We have about 20-some state departments. One department alone, state police, are processing 4,000 to 5,000 FOIA requests a year. Our department, the Attorney General, one of the smaller departments, processes about 1,000 requests a year. But any one time, the Attorney General is representing those state departments in FOIA lawsuits. That number may be 5 or 6. That's not a lot of lawsuits concerning the tens of thousands. Now, I'm not patting myself or anybody else at government on the back. What I'm saying is that with proper training and zealous processing, doing the people's business, there's no need for lawsuits. There shouldn't be a need for a lawsuit. Sometimes lawsuits are needed to clarify something that's not certain. We're in court right now on the subscription provision of the FOIA. In other words, I can subscribe to records that are routinely issued by the public body by saying I want them for 6 months, just like a magazine subscription, if you will. And at the end of 6 months, I can renew it for another 6 months, so that I don't have to make a FOIA request every week or 2 weeks or whatever. So that if the Department of Natural Resources hypothetically issues a report on the condition of streams and lakes in Michigan, and I know that they choose to do that, I say, I want a copy of that report every time you issue it for the next 6 months. Automatically I get it. That makes a lot of sense. But if I said I want any and all email traffic between the director of the department and the deputy, they don't have control over when or if they might. So those would not arguably be subject or qualify for subscription. Okay, but that's an important area. And there's a dispute going on right now between a requester and governmental bodies. And it's in the Court of Claims and may end up in the Court of Appeals. But that's good. We need judicial interpretation because the legislature really didn't tell us much more than records issued routinely, predictably. So courts tell us. We know how the 3 branches of government work, right? Okay, so it's a written request, and it comes in, and the public body is the other part of the relationship, okay? So the public body is one of 10,000 public bodies. It's going to process what you've asked for in writing, sufficiently described. And when the public body gives the information out, who's getting it? Who's getting the information? Well, the requester, Tom, of course, you just said that. The requester is getting the information. No, the whole world just got it. That information just went out to the whole world. Why is that? Because the FOIA provides no mechanism to prohibit or otherwise curtail the ongoing dissemination of that information. Because remember, the public body can't say, what are you going to do with it? Why do you want it? They better not be asking that. So what if somebody made a request for the personnel files of the Kent County Sheriff's Department? Are personnel files public records? Of course they are, because a public record is defined in the statute as any records, tangible things, electronic or otherwise, that are owned, used, in the possession of, retained, or maintained by a public body in the performance of its official function. It's everything. These notes that I have here, maybe useless notes, I don't know, but these notes that I have here are public records. I'm using those in the performance of an official function of the Department of Attorney General. You made a FOIA request, they'd have to be provided. If you are a public official, I won't ask you to identify yourselves unless you wish to, but if you're a public official here today and you're writing notes and you're going to take those notes back to your office and maybe use them for reference, you've just created public records subject to FOIA. Now remember, when I say subject to FOIA, the presumption is subject to disclosure under FOIA. It's a pro-disclosure statute, but it's a rebuttable presumption, meaning that maybe the information can be legally withheld, or parts of it could be withheld. So let's go to those personnel records of all the Sheriff's Department employees, civilian employees and uniformed employees, all the way up to the sheriff, him or herself. That public body may say your request is granted in part and denied in part. Oh, wait a minute, they're public records. How can you deny me in part? Well, because those personnel files contain personal information, really unrelated to the performance of the work the sheriff and the deputies and others do. They're home addresses. So the legislature permits information of that type to be carved out, to be redacted. You've heard of redacted information. All right, so it's a balance, isn't it? What is the overarching right in FOIA? What did James Madison tell us? The right to know. That's a right, constitutional right, if you will. But what about the right to privacy? What about the right to a fair trial? What about all those other constitutional rights and the rights that in customs and mores we value as a people? So you got this going on. So you're going to have to balance it, right? So the legislature provides a way to balance the information. All right, so you're granted in part, denied in part, but the public body can't just sit back and say, just trust us, we know what we're doing here. No, you have to explain in great detail why you're withholding those. We're withholding home addresses. Not good enough. Why is the withholding of home addresses an important determination by that FOIA coordinator on behalf of that public body? Because the disclosure of those home addresses could result in harm, threat, or endangerment to employees of the department, because they deal with a part of a population that somehow or other doesn't always want to play by our rules, and we don't really want anybody and everybody to know where the officer lives. Someone could counter that easily, I'm sure. There's two sides to every story, but the legislature allowed for this balance. So does that make sense? Or think about any information that government has on all of us. I always think government throws out this dragnet. It's a sticky dragnet. It pulls in a lot of information about us. So why would my home address or a citizen's home address who writes to Attorney General Nessel about a matter? Do citizens, or shall I say FOIA requesters, make requests for any and all letters that the AG receives? Oh yes, we have FOIA requests for the things that you wouldn't even think about would be requested under the FOIA. So that if a citizen writes to his or her government, there's no expectation of privacy when you petition government. However, under FOIA, it says you can redact personal information. And so we might redact the name and address of the citizen or citizens who wrote to the Attorney General about any number of things. We might leave in the city and state, because if it's Grand Rapids, Michigan, a lot of people live in Grand Rapids, so we're not worried about infringing on someone's right to privacy. But we might take out a name and a home address, a street address. We're allowed to do that. Okay, so we grant the request in part, we deny in part. There's 1,000,001 examples, and I'm not going to go through all of them. But again, it's that balancing of the right to know, which is the overarching, it's the presumed right. No right is greater than that until we find one that might at least balance against it to protect certain interests, all right? So that's the flavor of what's going on here. We know then that a public record means, again, I'm quoting from the statute, it's a writing prepared, owned, used in the possession of, or retained by a public body in the performance of an official function from the time it is created. That means wherever the record originated, that citizen letter originated on that citizen's kitchen table as he or she were maybe writing the letter, right? But once it's with the Attorney General or any public body, it's what? A public record of that public body, okay? So when we get citizen letters that might say, please treat my letter confidentially, I'm sorry, but it's not your letter anymore. It's now a public record of this public body. But we have the exemptions under FOIA that we might invoke on that, okay? So we know then that we have a right of access. We know that the public body has to process it. You know, if you're savvy on FOIA, within 5 business days after receiving that request, that public body better be on the job. And there's no excuse. Oh, we didn't see it. Oh, somebody else got it. Because even there, the legislature anticipated excuses and said, any employee of the public body that receives a FOIA request shall immediately forward it to the FOIA coordinator. No excuses. 5 business days come and go. The requester does not get a response. Now it's 6 business days. Now it's 10. We're well into an area of time where it's not likely that a circuit court judge, if they choose to sue, is going to be sympathetic. What were you guys doing with this request for almost 3 weeks? Oh, well, we were busy. Well, that's not going to cut it. All right, well, here's what we're going to do. I'm going to order disclosure of the records, and I don't even want to hear about exemptions. Since the requester, now a plaintiff, had to hire an attorney, you shall, public body, pay the attorney fees and the filing fee and any other costs that the requester incurred. And I'm going to tell you that the statute says that if you don't respond within that period of time, you shall be penalized punitive damages in the amount of $1,000. So plaintiff, you get $1,000 on top of it. What is the legislature doing? Encouraging all of us to be private prosecutors, okay? It doesn't have to be something where you choose to hire an attorney. You can, but why not? If you believe in your case, that is, the process was totally ignored. Personally speaking, I'd hire an attorney. I'd go to court, and I'd want that public body to learn from this inexcusable mistake. You blew off a citizen's right to know. It's a great and a constitutional right, okay? That makes sense, right? Open Meetings Act is the same way. If you violate that statute, you can be a private prosecutor on that. So, I know the Attorney General has mentioned recently that our office is going to look into ways that we might be able to assist citizens. There's nothing in FOIA that says the Attorney General or a county prosecutor can take on a case. This is civil right to the individual FOIA requester. But we will look, after we go through a determination on process, to possibly be the advance guard, if you will, on contacting a public body and saying, this is what's been alleged. If this is true, you have so many days to correct it. Otherwise, we would take further intervention if necessary. Okay? So, anybody made a FOIA request here ever? Okay. And were you satisfied? ACLU, of course. You will? Various degrees, I understand. It's like there's no such thing as, you know, justice is a rough form of justice, a rough form of truth, sometimes a rough form of being satisfied on FOIA requests. But every journalism department and every university and college in the state have a chapter in the textbooks they use that talks about news information or news gathering. And what's part of that chapter? It's going to be FOIA, Open Meetings Act, no matter what state it is. It's going to be talking about these as tools to acquire information. So if you are not satisfied with the response because you don't agree with the exemption, or you never got a response, you have the right to appeal to the head of the public body, the mayor, the chair of the school board, the attorney general, whoever heads the public body. The legislature put in an appeal step. It doesn't cost a thing to do it. and you're going to appeal and tell the public body, the head now, why whoever was down there, known as FOIA coordinator, messed up. Here's my reason for the reversal of the denial. Now, if you don't get a response at all, the legislature says in the statute, that's a denial. But a denial without a reason. That's why there's punitive damages. Failure to respond is a denial without any explanation. It is it. You get hit with those punitive damages. So you can appeal. I think that was a brilliant step that the legislature put into the statute because appeals are working. As I'm looking at them, they're working. Because it gives the executive office of that public body an opportunity to review and say, oh, they overlooked this, or no, they misinterpreted this record, or no, they didn't understand what was being asked for. So the appeal is keeping a lot of cases from going where? To the courts. So I think it's excellent. It doesn't always work because if they uphold the denial, let's say, and you can do the same with the fee. You dispute the fee, you say it's not an actual cost, it doesn't comply with the fee section of FOIA, you can appeal that too. But ultimately, we go to court for a final resolution on the matter, on that. And I always say there's no sin in being sued if it clarifies things for all parties and for the people generally, okay? And ACLU, you've had to entail suits, I'm sure, under FOIA.
Yeah, and I was going to ask you about that. We had an internal debate recently as to whether or not you have to file that request to the government entity before filing a lawsuit. That's just a little...
Well, I'll clarify it. Yeah, I'll clarify it for you. There's nothing in the statute that says you have to, an expression used in the law among attorneys, exhaust an administrative remedy. This is not an administrative process under the, I'll talk lawyer talk, the Administrative Procedures Act. So I can choose to appeal and then go to court if I'm not happy, or I can go right to court. My experience is people appeal. It doesn't cost. There's likelihood of a reversal. Not likelihood, but you want to see if there's a likelihood of a reversal. And it saves a lot of time and aggravation, if you will. All right, but again, you don't have to exhaust that step. And the same holds true now if you dispute the fee. And let's see, where's Jeff? Is Jeff still with us here? Jeff, I'm going to keep an eye on you because you're going to go time out. You get a lawyer talking and I'll stop when I'll make you a deal. I'll stop when they stop listening, okay? Okay, how about that? Okay, but I'll keep... 12 minutes. Okay, good. I'm glad I checked. Just about how much more material I have. How ironic is that? Okay, we talked about fees. The legislature says a public body may charge a fee to recoup its actual costs to search for, retrieve the records, examine them, review them, and segregate exempt and non-exempt. You may charge a fee. It doesn't say you have to. But you can't charge for any of what I just said, says the legislature, unless you show that failure to charge would result in what the legislature calls an unreasonably high cost to the public body in that particular instance. Every public body must publish procedures and guidelines. They must be available to a FOIA requester if asked for. They have to be on your website. Must spell out what is the threshold above which you charge and below which, of course, you don't charge. You have to give me, as a requester and citizen, notice of what I'm going to incur in fees if I ask for records. Now, a lot of requesters, even media, will ask for information in kind of broad strokes way and not realize how many records, especially with the state at the state level, how many records are involved. So we had a FOIA request from media that asked for a listing of the plaintiffs and defendants in all lawsuits that the state of Michigan is involved in, and we're the attorneys, so of course we know that. And a 2 to 3 sentence synopsis of every one of those cases. Now we've got the names of the plaintiff, we have that, yeah, but we don't do synopsis. We don't do summaries of the cases. We don't have time, we have no reason to do that. And FOIA says you don't have to create a record, you don't have to make up something you don't already have. But we try to be helpful. So we said to the requester, we're granting you this is readily available. We will do this, but for us to do this, we'd have to create a record, and to do that, the estimated cost is $70,000. Why is that? We have between 40 and 50,000 cases at any one time. Think about that, 40 to 50,000 cases at all levels of court at any one time. Well, the person was upset. But we explained again, this is not a record we have. Do you really need that? We can give you the information and you can go and look at it. You can do the investigative work by looking at it. So she said, okay, I think I understand. Forget that. Her fee went from $70,000 to zero. So again, she didn't realize what she was asking for. And that happens oftentimes with state of Michigan records, because we could have tens of thousands of records. So we always put into our notice, because there is a fee, if you would like to discuss ways to refine your request so as to lower the fee and shorten the processing period, please call us. We'll work with you. And we find that local units of government, I believe, personally speaking, I'm speaking on behalf of the AG, she may agree with me, maybe not, but I say that more government bodies need to do that. Where in FOIA does it say between the requester and the public body it's an adversarial relationship? It's not plaintiff versus defendant. It's not an adversarial relationship. We tell our state FOIA coordinators, you are again, I repeat, the gatekeepers of the First Amendment. You are there as the first and foremost and best purveyors of public service, because you're out there dealing with the public directly under the statute called FOIA. An opportunity. So many times after we give our notice and we put all the required provisions into the written notice, we might say at the end, in an effort to be of assistance, however, you may wish. We might think that the records they're looking for, we have a strong suspicion they're not with the Attorney General's office. They're probably with the Department of Licensing and Regulatory Affairs, because we know our records pretty well. So we might say, you may wish to make a FOIA request, not this one. This one's denied. You have the right to appeal. You have the right to sue us. If you want to prove that we have records that we say we don't, you can do that. But we'll refer them to another state department to determine whether we say that department might have records that fall within your description. We say might. Okay? We could be almost 100% sure, but we don't want to mislead anyone. What is that? That's public service. That is saying that the objective of the request is to get information. And our objective is to get you that information. It's not to stall you from getting it, to thwart you from getting it, to find ways to trip you up. And anybody in the FOIA business, as a coordinator, that doesn't have that attitude of public service, that's a problem. And that's a problem that may lead to unnecessary litigation. All right, so it's the idea then of that processing of information, getting the information out. Okay, moving on, then we've got a good overview. They always say in the law, if you don't have a right unless you have a remedy. So we spoke about these remedies. You have a right to appeal to the head of the public body. You have the right to sue. Okay, and we talk about exemptions, and I have here, there's 20, we ran out of letters of the alphabet. They're listed A, B, C, D. Now we're at the double A. These are all types of information that may be withheld. Others have to be withheld. If we had medical records about you, why would we have those? Well, you give 1,001 reasons we might have medical records of somebody. What about HIPAA? HIPAA, you've heard of HIPAA. HIPAA supersedes FOIA when it comes to certain records. You've heard of FERPA? Or our students here, Family Educational Rights and Privacy Act, the federal statute, supersedes the Michigan FOIA as to types of student records. There's records used in the administration of a state tax, and the Revenue Act, which established our Department of Treasury and all the taxes that go with it. But if a FOIA coordinator under a FOIA request gave out those types of records, 5-year felony, $5,000 fine, immediate firing from their job. I'm kind of paraphrasing the statute. That's a thou shalt not disclose under FOIA. All right, but those are some exceptions that are of some interest. But basically, you can take all of these exemptions and put them under 4 categories. These categories are not verbatim in the statute, but it gives you an idea. The first category, records of a personal nature, the release of which would result or constitute a clearly unwarranted invasion of an individual's privacy. So think about home addresses, medical records, all that sort of thing. The second category, the release of records which would impair the safety or security. I'm okay? Almost? Yeah. Yeah, this is the end right here. Yeah. So in other words, if someone made a FOIA request for the blueprints of a state prison down in Jackson, I don't think corrections are going to say, yeah, here's a copy of the blueprints. Public policy bases, attorney-client privilege, doctor-patient privilege. We have hospitals at the state level. Okay, all those types of privileges. And then records, as I said, exempted by other statutes. And there's many other statutes that will supersede FOIA. So that is, again, a quick overview. Questions? I'm sorry, go ahead. Yeah, looking at the federal FOIA itself does not include the executive branch of government. So the president is not subject to FOIA. And when Michigan, like many other states, determined that we better get a FOIA, it's very Watergate oriented. That was a trigger point historically why the states start saying we've got to get something to assure that there's no secrecy in and among government beyond a few case law that interpreted right to know. So then the governor in the state of Michigan was put in as not subject to FOIA. Massachusetts, I believe, is the only other state that by court decision says their governor is not subject. Governor Whitmer and Attorney General Nesso, as you may have read, are pushing to include the governor. We always get a grade of F among those certain organizations that grade on government transparency, and that's a big reason why the governor's not subject. Now, Whitmer has made available some records from her office, but that's voluntary, and of course, if it's voluntary, it's not mandated, obviously. But the federal FOIA is really a little bit more lenient in some ways. It says that you can withhold investigative records if they could result in an interruption of that investigation. Michigan says would result. So in some ways, Michigan is tougher than the federal exception by way of example. Okay.
And on the federal level, the time frame is longer.
It's 20-something, something longer, yeah.
Generally, the response time frame there's a huge backlog at the federal level. Michigan is quite responsive, but within the investigative community, I think Michigan, for those reasons that Mr. Quasanaro just delineated, is seen as one of the less transparent, largely because of the executive plan.
Exactly, that's why. And two, the federal only applies, obviously, to federal public bodies. So you journalists out there or students of journalism, if you're going to make a request, a FOIA request to a state of Michigan public body, do it under the Michigan FOIA. They still have to process it. Saying federal FOIA doesn't get you off the hook as a public body, but you want to look sharp when you do it, okay? Yes. Yeah, there's three questions or three parts of that question. The FOIA itself only deals with providing existing non-exempt records. If they don't exist for whatever reason, you can't force a disclosure under FOIA because no such records exist. Now we go to the next step. How is it that no such records exist? Well, the public body can show that it complied with the Department of Management and Budget Act, DMB Act, that sets forth something called retention and disposal schedules for all levels of government. You shall keep these records for this period of time. And there's many, many schedules that apply to various branches of government. It's statutorily mandated. And so, for example, as a public employee then, I would say accurately, I disposed of this record pursuant to a retention and disposal schedule versus I destroyed the record. Well, yeah, I destroyed it, but pursuant to a schedule. That protects the employee from a charge under the Michigan Penal Code for intentional destruction of a public record. That's a penal code matter. That would go to an investigative body, state police or county sheriff, for an investigative report to be turned over to the county prosecutor for prosecution. So that's a whole nother sanction. That punitive damage is nothing compared to what I believe the criminal sanction could be. As a matter of fact, it says that when you allow someone to come in to inspect your records under the FOIA, you shall protect your records from unauthorized mutilation, destruction, I forget the other words, but they all come from, that's literally from the Michigan Penal Code. It's reminding FOIA coordinators, you're responsible for protecting records. All right, so again, criminal more likely than a civil. Yes, John? Okay. Well, it's not reasonable fees, it's not the expression, it's actual, okay, actual costs. And now you have to have a fee form. I call it the hardware store nuts and bolts line item thing. You have to do that, and it's the lowest paid person capable of doing something, so that if Attorney General Nessel, for example, wanted to process the request, it wouldn't be her equivalent hourly rate, it would be the lowest person in the department that could do it. Someone else might do it that makes more money, but you're always going to this. So for example, in our office, if an attorney is needed to determine attorney-client privilege, it's going to be the lowest paid level attorney, not the highest paid level. So when someone said $113 an hour, I don't know all the facts. I don't know what the records were and why they would require somebody at that level to do the searching, retrieval, the examination, the review, the segregating of exempt and non-exempt, or any part of that. Okay, so that would be something you could dispute. Up to 50% of the benefits, right, by multiplier. But again, that's why the legislature amended going on 4 years ago, the right to appeal a fee and to dispute the fee. Because before that, our hands were tied.